You are either going to answer my question, or I'm going to hold you summarily in contempt, and the court officer will bring you to a jail cell, and we'll talk about it tomorrow. You understand that?
So,
Mr. McCloud, Mr. McCloud.
Yeah, I'm here by special appearance, and I will be representing myself.
Okay. I'm required by law before I accept that waiver to do a couple things. One, advise you of the maximum penalties that you could face for the charges that you're in my court for. Resisting, obstructing conservation officers is a high court misdemeanor punishable by up to 2 years in prison and or $1,000 fine. There's a habitual offender second notice that's been filed by the prosecutor, which would make that a felony punishable by up to 3 years and or $1,000 fine. And marine safety operating while intoxicated is a misdemeanor punishable by up to 93 days and or a $100 to $500 fine. Do you understand the maximum penalty for the charges against you? Do you understand the maximum penalty that I just explained to you?
No.
Hold on. I can't let you represent yourself until I establish a couple things.
Well, I need to establish a couple things too, honestly.
Hold on. Well, I can't let you represent yourself until I establish a couple things, or I'm going to be in trouble. Okay. Do you understand that the maximum penalty that you could face for the charges that you're here for is up to 3 years in prison and or a $1,000 fine?
I don't understand the nature and cause of the action against me. So
what is it that you don't understand? Do you not understand how long 3 years is, or how much the fine is that I've articulated? Can you tell me what it is you don't understand?
The nature and cause of the action against me because we don't establish jurisdiction.
That's not what I'm asking you right now. Well, I'll let you place whatever objections you want on the record, Mr. McCloud. I promise you that. Okay. Can we just go one step at a time? So do you understand the maximum penalty that you could face if you're convicted as charged? 3 years in prison or $1,000 fine?
Well, I have another question because the statutory jurisdiction doesn't exist under the Constitution. So in order for me to defend myself, could you please tell me where the published rules of conduct are for criminal statutory jurisdiction, or where I can find the nature and cause of this jurisdiction, or how this information exists?
No, I don't even understand what you're asking.
So you're saying this is a statutory jurisdiction under what? The statutes of Michigan, correct?
Mr. McCloud, I've told you what my jurisdiction is.
General jurisdiction.
The people of the state of Michigan voted to convene a constitutional convention in 1961.
Sure.
There was a constitutional convention in 1961 and 1962. They proposed a state constitution. The voters of the state of Michigan ratified that in 1963. Article 6 establishes the judicial power. And the circuit court is a court under that judicial power of Article 6 of the state constitution. And so you're here in my court. I have subject matter jurisdiction over those crimes. I have personal jurisdiction over you because you've been alleged to have committed them in our county. That's my jurisdiction. So, Mr. McCloud, do you want to represent yourself? Do you understand the maximum penalty that you could face of 3 years in prison and or $1,000 fine?
Sure.
I'm going to ask you this question one more time. One more time.
Okay.
Two things are going to happen. You are either going to answer my question, or I'm going to hold you summarily in contempt, and the court officer will bring you to a jail cell, and we'll talk about it tomorrow. You understand that?
So,
Mr. McCloud, two things are going to happen. You're going to answer my question, or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McCloud, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges.
Mr. McCloud is in contempt court, taken into custody.
Really? That's it. Protecting my rights is what fucking job. This isn't true. You guys are
follow unconstitutional orders.
Follow unlawful orders. It's not constitutional at all.
Mr. McCloud's in contempt, he's sentenced to 1 day. Mr. McCloud, your sentence is 1 day in jail. We'll reconvene tomorrow and get you
This is
notice.
about the Constitution. I did nothing wrong except the question and exercise my rights.
Please come up to the podium so you can be on a microphone. Otherwise, your statements won't be recognized.
I'm Anthony Meyer. And appear by special appearance to challenge jurisdiction.
Wait until you're at a microphone, sir, so you're being recorded, please.
Okay, very well.
There at the podium.
Approach special appearance only, not as the named entity.
Come on up to the microphone, please. Let me ask, are you Anthony Meyer? Yes or no?
I am Anthony Meyer and appear by special appearance to challenge jurisdiction and confirm administrative default to avoid joinder. And I am approaching under special appearance and not as the named entity.
This is the case of the People versus Anthony Meyer. Are you Anthony Meyer? Yes or no? And that will determine whether or not there's a failure to appear today.
I am, Your Honor, I stated that I am Anthony Meyer.
Okay,
Hereby
so,
special appearance.
Mr. Meyer, you've already made your statement.
Objection.
You've made your
You're
statement.
interrupting me, please.
You've already made your statement this morning. Now,
Anthony
we need to
Meyer,
reset
and
the case for
hereby
trial.
Special.
You've already
appearance.
said that, right?
I'm only here to settle the accounting.
So you have two options. You can go to trial, or you can plead guilty or no contest to the charge of no insurance. You want to have the
I'm
case
hearing-
reset for trial? Yes or no?
I'm here in honor to settle the matter.
Then let's settle it. If you want to know proof of insurance, you can take that. If you want to go to trial, you can do that.
Can you have the DA read the charges into the record?
You're charged with no proof of insurance. You can plead guilty, no contest, or proceed to trial again.
I don't see any proof of the charging instrument. And,
You
or
were
any of
issued
the
a summons and
certified
complaint
accounting.
that's adequate to inform you of the charges. You test or stand by the not guilty plea that was entered by the court on your behalf, and we will reset the case for trial. How would you like to proceed?
Before this court can proceed, the plaintiff must rebut the administrative judgment and provide a verified claim by the party with firsthand knowledge.
That's inaccurate. We're going to set it for trial again.
Jurisdiction remains unanswered, and there is an unrebutted administrative judgment on the record, and I request for dismissal.
A motion to dismiss denied. Let's set it for jury trial on, I got speedy trial restarting as of today's date.
Your Honor, for the record, I do not see the officer present in the courtroom, and without a sworn complaining witness with firsthand knowledge, I move the matter to be dismissed.
Motion to dismiss is denied. The officer does not have to be here today. We're going to set it for jury trial on May 7th
I have
at 8:30.
I've yet to see an offer from the DA. Can Mr. Epson please read the charges into the record?
The offer is no proof of insurance.
Okay,
Plead guilty.
can I see those charging instruments and the certified accounting for that?
We're done.
I do not see the certified accounting for the charges or the charging instruments, and I again request dismissal. I'm hereby special appearance to confirm the administrative default. I've given you guys the motion, or sorry, the notice. I've given you guys the notice, order, and the motion to dismiss, and I've also put into the record an acceptance of offer. And again, Anthony Meyer, the living man, accepts the presentment of the offer for the case number 23T0294 to set off, settle, discharge, and close all accounts, including but not limited to the equitable subrogation IRS 941, the 941V, the 1099A, C, and OID, or supplied supersedes bond. I, Anthony Meyer, the living man, does not consent to go to prison on behalf of the named defendant, estate Anthony Janae Meyer.
Mr. Meyer, your motions are non-persuasive and essentially gibberish. Motions to dismiss are denied. The case is being reset for jury trial. You've seen what happens if you pull this at a jury trial. It will register as a failure to appear. A new warrant will issue, and we'll keep going through this
I'm here in
until
honor.
you show up and acknowledge in front of a jury that you are Anthony Meyer. So again, you can go back to trial, We've set a trial date, or you can plead guilty or no contest. Last chance, want to set it for trial? Yes or no?
Again, I'm here by special appearance to
Okay,
challenge
we're
the
going to
jurisdiction.
trial May
and to confirm
7th
the
at
administrative
8:30. We're
default.
going to do a status pretrial conference with a mandatory appearance.
I'm here in honor. And the DA is yet to present me anything, no offer, has showed no proof. Officer is nowhere to be seen. I'm present right here in front of you. You're saying that I'm not here. I'm
Judge, for the
telling you that I'm
record-
here
For the
especially.
record, the officer was here
No, he
on
wasn't.
Thursday. Both officers came in one came in from Flores, one came in from Park County.
The officer
Maybe
does not,
these
Mr.
officers,
Meyer, the officer
but
does not
provocative.
have to be here today.
He's
You
never
are-
been here for any,
He
for
was-
not the arraignment, not for the hearing, nor was he here for the jury. And then you
Had-
said that I wasn't here last time when I was present right here in front of you,
I called
telling
for
you.
Anthony Meyer twice. You refused to have a seat, so I found you failing to appear to be tried.
And I was telling you that I'm
Had
here by
you taken
special
your
appearance.
seat, had we sworn a jury and had the officer not appeared, it would have gotten dismissed. That didn't happen because you failed to take your seat at the defendant's table. So
I was willing to take my seat,
No,
Your
you
Honor.
were
I just
not.
wanted to let you know that I was here by special appearance to settle the matter.
Okay.
And again, today I'm here only to settle the matter.
the only way to settle it is to plead guilty or no contest.
Are you practicing law from the bench?
No.
No, I'm
Okay.
making the
We're
offer.
done.
Entered a plea on my behalf the first time.
As the statute authorizes, if someone refuses to plea, the court can enter a not guilty plea. So head down the hall, they'll get your paperwork. We'll see you here in person, March 4th at 3 o'clock for pretrial conference. And the case is set for jury trial May 7th at 8:30.
You guys have my offer, and so I'm waiting for the certified accounting and for the instrument for this to be able to proceed forward. So
Don't hold your breath. Go down the hall to the
We'll be the
clerk's
same.
window. Thank you.
Thank you, Your Honor.